Welcome back to Inside Politics as we continue to look back at the recent Tennessee August elections. One of the successful candidates on Thursday night was Supreme Court Justice Connie Clark. Justice Clark, thank you for coming on the show. It's a great honor to have you with us, and congratulations on your new term.
Thank you, and thank you, Pat, for having me here.
Now, I know you're happy, but aren't you also kind of relieved? I mean, you and the other two justices had to go up against one of the most powerful elected officials in Tennessee, and Ron Ramsey, and he and some other groups were literally trying to take your job away. I don't think that's what you expected when you decided you wanted to seek another 8-year term.
It is not what we expected, but Pat, today I think we are happy and excited because we took our case to the citizens of Tennessee and they responded. And I think this is a victory for them and not just for the three of us.
Now, did you take this removal effort seriously from the beginning? Or at first you was like, well, that can't be possible. They're not going to do
We took it seriously from the very beginning, particularly when we learned that the Lieutenant Governor himself had a personal interest in it. You can't ignore something that another popular elected official is talking about.
But it's unusual for justices who don't normally run in races like this to go out and say, okay, we're going to commit to doing the research and the planning and all the other things, particularly it's involved in campaigning. I mean, did that take a little mindset change for you?
It did. The Tennessee plan, as enacted by the legislature, does not presuppose that we'll have this kind of race. It has an evaluation process, and I think it suggests that once you've been evaluated and a commission has recommended you, that will give enough confidence to the voters.
If you'd known back several weeks ago or months ago that both sides would wind up spending $1 million on television, would that have taken you back?
Absolutely.
Does it still take you back?
I would never have thought that was possible, and I haven't seen the final numbers, but I have heard that number reported, and I know a lot of money was spent.
Now, what has been your involvement in the past on the campaign trail? Have you been an active candidate before for office the way you had to be in this particular situation?
I have, but it's been a long time ago. In 1984, as a young lawyer, I actually ran for a seat in the Tennessee legislature and won a primary but lost the general election to an incumbent.
So how has campaigning changed from what you remember in 1984?
Oh, it's changed a lot. In those days, we talked about issues, and we talked about the things that you would do as a legislator, but of course that's very different. That is a job where you are going to represent the wishes of your constituents and where it's important to know what the issues are and to talk about them. I ran a contested judge race in 1998 as a circuit judge, and that was governed by similar ethical rules. But even that was a different race from this one.
You had some experience, but you traveled the state again, you made speeches, you appeared at campaign events. How were you and the other justices? Were you comfortable in those atmospheres, or did you feel a little like a fish out of water?
That analogy is yours, but it may be a good one. It is not something that feels comfortable to stand up and talk to groups, because all we can talk about is the oath we have taken. We can't make any promises except to enforce the law fairly as to everyone. And that it's an important thing, but it doesn't make for good discussion.
Another part of being out on the campaign trail is raising campaign funds, and that means going and talking to people, I assume in some cases face-to-face, asking them for money to fund your campaign. That puts you in a pretty delicate situation, especially since you're going to be asking it in some cases from people who either have argued cases in front of you, have cases in front of you, or will in the future.
If we did that directly, that would make the situation even worse than it was. We can't, under our ethics rules, ask for money. We can ask people for their votes. We can ask them to support us generally, but in order to raise money, we have to find a friend to be a treasurer or a group of people to be a committee, and they have to make the actual asks.
Now, this retain replace election has been used in several cycles over time, although it's not actually in the Constitution, and we'll talk about that in just a minute. It's only worked before in terms of an ouster with Penny White. Do you feel that your opponents and the way they ran their campaign were fair to you, fair to the other justices?
No, I don't. This campaign was filled with misstatements, with innuendos, with distortions, and with some things that were just outright lies.
But politics in campaigns always fudge the truth. At least that's what most people think. So what makes this really any different?
Well, it should be different because you're talking about judges, and what I think the discussion should be about is their record, not with the use of emotion-filled words or buzzwords, but with a real review and analysis of their cases. I don't think that happened much in this election.
Any hard feelings going forward, or are you just going to go ahead and go back and you and the other justices just do your job?
We're just going to do our job. There can't be hard feelings. People have a right to disagree about their opinions. If we have meant what we said, that we take our oath seriously, then we just need to go back to work and do our jobs.
I mentioned the constitutional amendment that's coming up in November that keeps retention elections like this every 8 years. As someone who's been very up close and personal with the opportunity to do that in a very expensive, time-consuming, controversial way, are these the right way to start doing our elections for judges?
I'm convinced that partisan political elections where people campaign on the basis of party label will never be a good idea for judges. And so retention elections are always going to be better. I hope that others don't ever have to face exactly the kind of election we faced.
Now, the amendment that's up there also would allow the State House and State Senate to have confirmation powers over future Supreme Court justices as they're appointed by the governor. In your mind, is that a good idea, or is that sort of tipping the balance of power between the three branches of government a little bit too much one way?
I think it creates the possibility that it could tip too much one way. As I understand the discussions that went on about that amendment, it may be a compromise that was worked out among those who ultimately passed the resolution. But once the details of that are worked out, I hope that the members of the legislature will remember that their responsibility is to judge only a person's ability to be fair and to impartially enforce the law.
The new Supreme Court will start its term in September. One of your first jobs will be to select a new Attorney General. What are going to be the court's procedures for selecting that, and how will you be able to do it in a way that people don't feel like their party affiliation is the reason somebody selects an AG?
Beginning early next week, the five of us who now know we will be going forward are going to finalize the procedures, and they should be announced publicly very soon. But we're going to make this as open a process as possible so that people will be able to know who the applicants are and be able to follow the process as it goes along.
Justice Clark, thank you so much for coming in. Appreciate you being with us.
Thank you so much, Pat.
Okay, let's take a break. We'll come back and talk to Tom Humphrey and look at what he has to say about the changes from the August election in the Tennessee General Assembly. Back after these messages.